SRIRAM's IAS, serving the nation since 1985. Ab offline ho ya online, we are the lifeline.
Hello friends, welcome to SRIRAM IAS. Today we'll be studying about fundamental rights. We have already covered Article 12 and Article 13, which defines the state and law respectively. But from here starts the real fundamental rights which have been given to the citizen of the country. So fundamental rights, we'll be also studying this slide about Article 14. अब देखा जाए कि what is this fundamental rights? There are few questions which are written here. We are going to see them one by one. तो फंडामेंटल राइट सबसे पहले तो पार्ट 3 में एनश्राइंड है कॉन्स्टिट्यूशन के पार्ट नंबर 3 में आर्टिकल नंबर 12 से आर्टिकल नंबर 35 तक. दिस इज व्हाट इज फंडामेंटल राइट. तो पहला क्वेश्चन है व्हाट फंडामेंटल राइट्स आर अवेलेबल टू द सिटीजन्स एंड of course to the non-citizens also. Some of the fundamental rights are given to the citizens and many of them have been extended to non-citizens also. जो लोग हैं जो बाहर से इस देश में रहने आए हैं, जो यहाँ के नागरिक नहीं हैं, उनको भी कुछ फंडामेंटल राइट्स कॉन्स्टिट्यूशन ने दिए हुए हैं जो कि ज़रूरी भी है एक सिविलाइज सोसाइटी में. अपने बहुत सारे लोग हैं इंडिया के जो बाहर रहते हैं who are not the citizen of that country but they have been extended some fundamental right related to life, related to equality before law. Those are important for the functioning of the country in a civilized society. So fundamental rights which are available. So let us just see what fundamental rights are there. Article number 12 deals with state, whereas article number 13 deals with law. ये हमने देखा rules, regulations, ordinance, order, notifications, customs, everybody is covered under this. We have also already seen whether amendment is the part of law or not, and we have also seen what has happened after Keshwananda Bharati judgment coming of the basic structure doctrine. Then comes from article 14 to article 18, you see this is equality. In its different perspectives, equality has been enshrined in the constitution. Article 14 एक बहुत broad interpretation है equality का. Article 15 and Article 16 particularizes that particular Article 14. Article 14 में जो बोला गया है उसको बहुत ही माइक्रोस्कोपिक वे में Article 15 और Article 16 में बोला गया है. उसको स्टैंडर्डाइज किया गया है इंडिया के अकॉर्डिंग. The religion, race, caste, sex, place of birth, these may not be the issue in some other country. Like हमारे लिए caste की equality एक बहुत बड़ा issue है. There is ample amount of inequality in India based on caste, but that is not a issue in Western countries. वहाँ पे race का issue है. तो Article 14 is a widely applicable article to all the people, all the citizens, non-citizens, which is also there in French constitution, English constitution, and other constitution like the United States, everywhere. But 15 और 16 particularizes that article number 14. It is very important to understand. So 14 से लेके 18 तक equality define करता है. अब आता है article number 19 which defines freedom. Defines freedom or gives freedom. It is enshrined. So articles में article clause 1, clause 2, clause 3 करते करते 6 clauses हैं. आर्टिकल 19(1) में 6 तरह की फ्रीडम्स डिफाइन की गई हैं. वहीं आर्टिकल 19 के क्लॉज 2 से लेकर क्लॉज 6 तक रीजनेबल रिस्ट्रिक्शंस डिफाइन की गई हैं. इन सबको अपन आने वाली क्लासेस में एक एक करके विल स्टडी दिस. बट नाउ कम्स आर्टिकल नंबर 20, 21 एंड 22. Talks about freedom of body, freedom of person, an individual, right to life and personal liberty. Article 21 देता है. Article 20 में if somebody has been arrested, so what kind of rights are available to a person who is being arrested? That the person must not be self-incriminated. At the same time, there must not be double jeopardy. That simply means the same person cannot be punished for the same crime twice. At the same time, Article 22 tells about a bit of a procedure that a person should be given information on the basis, on what basis the person has been arrested, the grounds must be told to the person who has been arrested, and at the same time he must be taken in front of a magistrate within 24 hours. नहीं तो पुलिस किसी को भी गिरफ्त करके कितने भी दिन कहीं पे भी रख सकती है, प्रिवेंटिव डिटेंशन में होता है. प्रिवेंटिव डिटेंशन का क्लॉज आर्टिकल 22 में दिया गया है. वी विल स्टडी दैट ऑल्सो इन कमिंग क्लासेस. 23 and article 24 is rights against exploitation. किसी भी तरह का exploitation specially related with bonded labor, human trafficking is not allowed under the Constitution of India. Child labor is also not allowed. Forced labor is also not allowed. These are the kind of exploitation which can be done to the human being and has been done in history. बेगार एक बहुत बड़ी समस्या थी इंडिया में, which has been abolished now. Forced labor अभी भी है, child labor अभी भी है, human trafficking अभी भी एक समस्या है. तो rights दिए गए हैं. Article 25 to Article 28 gives freedom to profess, propagate and practice any religion. right to conscience भी इसको बोलते हैं. किसी भी तरह का रिलीजन अगर आप फॉलो करना चाहते हैं तो यू कैन गो अहेड एंड डू दैट. फ्रॉम आर्टिकल 25 टू आर्टिकल 28 matters related with freedom of religion has been specified in the constitution under part 3rd. अब आता है आर्टिकल 29 and 30. there are minorities in India. there is cultural minority, linguistic minorities. So rights has been provided and extended to such minorities under Article 29 and Article 30 in the Constitution. Article 31 repeal हो गया था. Article 31 A, B, C है. In some or the other way it restricts the fundamental right. एक तो उसमें बोलता है कि directive principle of state policies, जो कि एक तरह से rights ही हैं, but those are not justiciable. अगर वो breach होते हैं तो you cannot go to the court कि आप ये ब्रीच हो रहे हैं एंड देन प्रोवाइड सम रेमेडी टू इट. कैन नॉट बी डन विद दोज DPSP. बट कुछ जगहों पर अब कोर्ट हैज अलाउड दैट इफ सम ऑफ द फंडामेंटल राइट अंडर आर्टिकल 19 और अंडर आर्टिकल 14 and under article 19 has been infringed because of the implication of directive principle of state policies, those actions by the legislature or by the executive are allowed. ये एक बहुत बड़ी चीज़ है. तो आर्टिकल 31 रिपील्ड है, A, B, C आर्टिकल 31 में जो चल रहे हैं अभी. आर्टिकल 32 इज known as the soul of the constitution. Why? Because it provides the remedies. Provides the remedies. That simply means under Article 32, using Article 32, you can go to Supreme Court and High Court directly. 226 आर्टिकल में आप हाई कोर्ट जा सकते हैं, 32 में आप सुप्रीम कोर्ट जा सकते हैं. इफ एनी ऑफ योर फंडामेंटल राइट हैज बीन ब्रीच्ड, डायरेक्टली यू कैन गो टू द सुप्रीम कोर्ट. एक डायरेक्ट रेमेडी दी गई है सिटीजन्स को कि यू कैन मूव टू द सुप्रीम कोर्ट डायरेक्टली एंड आस्क द सुप्रीम कोर्ट टू सॉल्व द इशू, टू लुक आफ्टर द इशू, डू द कंप्लीट जस्टिस अंडर आर्टिकल 32. वेरी पावरफुल आर्टिकल. ये एक आर्टिकल है, अगर जिसको हटा दिया जाए तो those articles are of no use. All the above articles are of no use. क्योंकि आप आर्टिकल मेंशन कर सकते हैं कॉन्स्टिट्यूशन में, बट उसको एनफोर्स करने के लिए कुछ तो पावर दी जाए, वो 32 के अंदर दी गई है. They are enforced under Article 32. If any of them have been breached, you move to the court for justice under Article 32. And of course, under Article 226, when it is the matter where you have to go to the High Court. Article 33 restricts the fundamental rights of the forces. अब पुलिस है, सेंट्रल प्रोटेक्शन फोर्सेस हैं, CISF है, CRPF है. अगर आपने इनको सब तरह के राइट्स दे दिए, राइट टू फ्रीडम ऑफ स्पीच एंड एक्सप्रेशन, दे विल कम अप एंड से थिंग्स एंड स्पीक थिंग्स which will be detrimental to the security, unity and integrity of the country. Armed forces hai, they cannot be given all the fundamental rights. Although they are the citizens of the country, but at the same time the fundamental rights given to them are restricted under Article 33. Just to maintain the law and order, just to maintain the security of the nation, it is of paramount importance that all the fundamental rights in its wider proportions cannot be extended to the forces. ये कहता है आर्टिकल 33. आर्टिकल 34 में this has not been the article which was originally there in the draft constitution but was later on added. बिल्कुल जब constituent assembly से पास होने वाला था constitution, at that time article 34 was added which says that martial law जब country पे लगता है, मार्शल लॉ के अंडर अगर कंट्री है तो फंडामेंटल राइट्स जो रहते हैं आपके वो रिस्ट्रिक्ट हो जाते हैं. इट इज रिस्ट्रिक्टेड. गवर्नमेंट में बैठे लोगों को एक्स्ट्राऑर्डिनरी पावर मिल जाती है मार्शल लॉ के समय एंड योर फंडामेंटल राइट्स मींस फंडामेंटल राइट्स ऑफ द सिटीजंस आर रिस्ट्रिक्टेड. आई एम सेइंग एक्स्ट्राऑर्डिनरी पावर, आई एम नॉट सेइंग एब्सोल्यूट पावर मिल जाती है. देयर इज अ डिफरेंस बिटवीन बोथ ऑफ देम. आर्टिकल 35 बोलता है कि कुछ केसेस ऐसे हैं और फंडामेंटल राइट्स से स्पेशली रिलेटेड द लॉज विच विल बी मेड बाय द पार्लियामेंट, not by the state legislative assemblies. This is important to understand. Okay, so these are the fundamental rights which are enshrined under part 3rd of the constitution from article 12 to article 35. We have seen all the articles here. Now let us come to these questions. तो पहला क्वेश्चन तो अपन ने आंसर कर दिया है. What fundamental rights are available? So these are the fundamental rights which are available to the citizens of India, to also extend it to the non-citizens. Okay, against whom fundamental rights are available? तो इसमें अपन देखेंगे कि there is a vertical extension and there is a horizontal. What is this vertical extension? They are being given against the state. If state comes up and does something which infringes or abridges your fundamental right, either it makes a law, passes a notification or an ordinance which in any way, shape or form is infringing or abridging your fundamental right, then it is not permissible to be done so. And under article 32 you can approach the court. So fundamental rights are actually given against the state. Vertical extension of fundamental right, that is what is vertical extension, against the state. But there are few fundamental rights which are also being given against the private citizen. Now that will be called as the horizontal extension. I hope you understood. Horizontal extension में फंडामेंटल राइट्स वो वाले जो प्राइवेट सिटीजन के अंडर अगेंस्ट दिए गए हैं. अब आप देखिए इसको ध्यान से. आर्टिकल 17 जैसे है इक्वालिटी में, अबॉलिशन ऑफ अनटचेबिलिटी. तो एक पर्सन हु इज नॉट अ स्टेट, एन इंडिविजुअल कैन ऑल्सो डिस्क्रिमिनेट अ पर्सन एंड प्रैक्टिस अनटचेबिलिटी. तो ये फंडामेंटल राइट अगेंस्ट द स्टेट तो है ही, बट अगेंस्ट इंडिविजुअल भी देना जरूरी है. नहीं देंगे तो कल को अनटचेबिलिटी की प्रैक्टिस स्टेट तो नहीं करेगा बट इंडिविजुअल्स करने लगेंगे. एट द सेम टाइम आप देखिए, राइट्स आर गिवन अगेंस्ट एक्सप्लॉयटेशन अंडर आर्टिकल 23 एंड 24. फोर्स्ड लेबर, चाइल्ड लेबर, ह्यूमन ट्रैफिकिंग, all these kind of exploitation, although they are not expected from the state, but at the same time they are also not expected from the individuals. एक इंडिविजुअल आदमी है वो भी तो ये सब कर सकता है, किसी को एक्सप्लॉइट कर सकता है, ह्यूमन ट्रैफिकिंग में इन्वॉल्व हो सकता है, गैंग्स होती हैं, ग्रुप ऑफ पीपल आर देयर. वो स्टेट नहीं है, वो प्राइवेट सिटीजन्स हैं. बट फंडामेंटल राइट्स प्राइवेट सिटीजन्स के अगेंस्ट भी दिए गए हैं. नॉट ऑल द फंडामेंटल राइट्स आर अगेंस्ट द स्टेट, मैनी ऑफ देम आर अगेंस्ट द प्राइवेट सिटीजन्स ऑल्सो. एट द सेम टाइम राइट टू लाइफ आपको दी गई है. वन पर्सन कमिट्स मर्डर ऑफ द अदर पर्सन, अ पर्सन इज नॉट अ स्टेट बट अ प्राइवेट इंडिविजुअल हु इज इन्फ्रिंजिंग योर फंडामेंटल राइट. तो उस समय क्या होगा, The fundamental right is also extended against a private citizen. So, to answer this question, against whom fundamental rights are available, they are available against the state and they are available against the private citizens as well. I hope you understood this point. To whom fundamental rights are available? Of course, they are available to citizens and they are also available to non-citizens. Think about a let's say American person or a person from a British origin who is not the citizen of India and is living in India. क्या आप उसको right to equality भी नहीं देंगे? उसको equal treat नहीं करेंगे? State, don't you think must extend this right to equality to a person who is not the citizen of India? The person must be treated equally in front of law. In the liabilities imposed, in the rights which are given, the protection which is given, the person, does not matter whether a citizen of India or not, must be given the right to equality. So, fundamental rights are available to citizens, but they are also available to non-citizens. अब यहाँ पर अगर अपन देखें सिटीजन्स को जो फंडामेंटल राइट्स अवेलेबल हैं विच आर अवेलेबल ओनली टू सिटीजन्स, तो आप देखेंगे आर्टिकल नंबर 19 राइट टू फ्रीडम, ये अपन ने नॉन सिटीजन्स को नहीं दिया है. अगर उनको ये राइट दे दिया तो आर्टिकल 19 के अंदर बहुत से राइट्स आते हैं. राइट टू फ्रीडम ऑफ स्पीच एंड एक्सप्रेशन, असेंबली, फॉर्म एसोसिएशन, movement, they can move anywhere freely within the country, territory of India, settle and residence. ये rights अगर अपन ने extend कर दिए to non-citizens, think what will happen. The people who are not the citizen of India, they can come and reside anywhere. They can come and move anywhere within the country. At the same time, they can form associations which can be anti-government, can be anti-people. So, it cannot be given to non-citizens. So, बहुत सोच समझ के in a very reasonable and a logical manner, these fundamental rights have been classified. Which of them can be given to individuals who are citizens and which of them can be given to individuals who are non-citizens. Similarly, Article 15 and Article 16, which classifies few grounds on which there must not be any kind of discrimination, religion, race, caste, sex, place of birth, उसमें भी इन्हें नहीं रखा गया है. They are not there. Non-citizens are not there under Article 15 and 16. At the same time, if you see cultural rights, the religious rights are given to non-citizens, but the minority rights given to the minority under Article 29 and 30 have also not been extended to non-citizens. ये भी सोचने लायक, देखने लायक बात है. Now comes fundamental rights are absolute or restricted. It's a very important question. Of course, they are restricted. Fundamental rights are always restricted. No right which has been given to the citizen are absolute. अगर आपने absolute right दे दिया, there will be chaos. Governance fail हो जाएगी. There will be like restlessness throughout the country. Absolute right cannot be given to somebody. Right to equality कभी absolute हो सकता है क्या? अगर right to freedom absolute हो गया तो आप सोचिए क्या होगा. फिर तो freedom of speech and expression है. I can go on and speak anything. It does not matter whether I am doing contempt of court. It does not matter whether I am hurting a person or defaming the person. It does not matter whether I am creating some sort of law and order problem. So, fundamental rights are always restricted. They are not absolute. What are the restrictions which are there? Law and order is one important. Law and order. Defamation of a person if you do that. Contempt of court, which is not allowed. You should not speak something which contempts the court. Criminal contempt or civil contempt, any kind of contempt, not allowed. At the same time, if we have any friendly relation with any nation, then these must be restricted, or else our friendly neighbor or maybe our friendly relative in the terms of state may turn hostile towards us. That is also not permissible under Article 19. Reasonable restrictions are always there. So these are several reasonable restrictions. We will study, when we study Article 19, we will study completely and fully what reasonable restrictions have been provided and at the same time what freedoms are given. We're just watching over the whole area of fundamental rights, or what are the contents, what kind of provisions which are related with the fundamental rights in this class. So they are of course restricted. There are reasonable restrictions which have been extended to fundamental rights, and no right can be absolute. अब आप कहें कि हमारा fundamental right to practice and profess our religion is absolute, and you do several activities which is unscientific and against the morality and decency, that is not allowed. Morality and decency has to be there. Follow whichever God you want, follow whichever religion you want, follow or do not follow, that also depends on you. You can be an atheist, but at the same time whatever you follow must not create some sort of law and order problem or problem related with morality or decency. You have to be moral, you have to be decent in following whatever you are following as a religion. So these rights, they are not absolute. Remedies are also not available in all the cases. Your grounds must be reasonable. Everybody approaches court under Article 32, but court does not accept all petitions. It rejects several petitions. जहाँ कोर्ट को लगता है कि these petitions are nowhere infringing the fundamental rights, court rejects that petition. It does not accept that petition. Now, this important question whether fundamental rights are negative or positive. In the cases where we say that the fundamental rights are negative, that simply means it is restricting the state from doing something. It is restricting the person or an individual from doing something. That is why it is called as negative. The state must not deny to any person equality before law or equal protection of law. The state must not deny. That simply means the state must not do something which infringes the right to equality. At the same time, state must not do something. And when I am saying do something, it simply means state can bring legislation, it can bring notification, executive orders, there can be anything which can be done by state. And when you are restricting the state or limiting the state from doing something, that simply means you're creating a negative perception of that right. That's why it is called as negative right. But at the same time, there are positive rights as well. And what are these? Positive rights simply allows the state to do something to bring in equality, justice, liberty in the country. Equal protection of law, a special provision for children, for women. Any of these things which helps the state to implement the fundamental rights, which helps the state to do something rather than restricting the state from doing something, are the positive rights. आर्टिकल 15 आप देख लीजिए, आर्टिकल 16 देख लीजिए. अफर्मेटिव एक्शन बोलेंगे, रिजर्वेशन के लिए लिस्ट बनाना, रिजर्वेशंस देना, स्पेशल प्रोविजंस बनाना फॉर चिल्ड्रन, फॉर डाउनट्रोडन्स, फॉर वुमेन. तो state is actively involved in doing something. You are not restricting the state from doing something. स्टेट को रोक नहीं रहा है, स्टेट को बोला जा रहा है कि आप कुछ प्रोविजंस बनाएं. सो दोज काइंड ऑफ राइट्स जहां पर स्टेट को प्रोविजंस बनाने के लिए कहा जा रहा है, स्टेट को कुछ करना पड़ रहा है, एक्ट करना पड़ रहा है, दोज राइट्स आर पॉजिटिव राइट्स. और जहां स्टेट को रिस्ट्रिक्ट करा जा रहा है, बिकॉज स्टेट हैज टू मच पावर एंड इट शुड नॉट टर्न इनटू एन एब्सोल्यूट स्टेट. एब्सोल्यूट पावर उसके पास ना आ जाए, फॉर दैट रीजन द पावर्स ऑफ द स्टेट मस्ट बी रिस्ट्रिक्टेड, इसलिए बोलते हैं उसको नेगेटिव राइट. सो देर आर फ्यू राइट्स विच आर नेगेटिव राइट, देर आर फ्यू राइट्स विच आर पॉजिटिव राइट. नेगेटिव राइट में स्टेट की पावर को रिस्ट्रिक्ट किया जाता है, पॉजिटिव राइट्स में स्टेट को अलाउ किया जाता है टू मेक प्रोविजंस फॉर द बेटरमेंट ऑफ द सोसाइटी. So I hope you have understood these questions and you have understood the concepts which we have studied in the rights. Now let us see Article 14. Let us begin our discussion here. What is Article 14? So equality before law and equal protection of law. बहुत philosophical concept है, बहुत सारे लोगों को समझ नहीं आता है. We are going to study it in as simplified manner as we can. Let's start with equality before law, and this is equal protection of law. Both are mentioned in Article 14. Equality before law, simple. This is absence of favoritism or partiality. It also means that everyone must be treated equally before law. This is a very brute or an absolute concept of equality. Sub, it does not matter from which class you belong to, it does not matter which caste you belong to, doesn't matter what is your gender, you are all equal in the eyes of law. All are equal in the eyes of law. That is what is called equality before law. This has its origin in the British Constitution and generally is considered as a negative concept. We have studied what is negative concept. It restricts the state from doing some things which brings inequality. So everybody is equal in front of law. In the eyes of law, all are equal. It doesn't give any favor. It doesn't do any partiality. Okay, I hope you understood. It's a very simple thing. बहुत सरल है. Everybody, does not matter from which class or creed or race you belong to, from which religion you belong to, what is your gender, it just doesn't matter to law, because for law everybody is equal. Liabilities हो, liability impose करना हो या फिर rights प्रदान करने हो, किसी भी केस में differentiation नहीं होगा by state. That is called equality before law. Equal protection of law, on the other hand, is a different concept. It says that equality, equal treatment for, it's a very different concept which is also a positive concept. Remember this. This is a positive concept and taken usually from the American Constitution. Or similarly circumstanced. Similarly circumstanced. अब ये समझना बहुत जरूरी है. Those people who are like, who are similar to each other, not identical, but similar to each other. उनका रहन सहन, वे ऑफ लाइफ, देयर हिस्ट्री, that is similar. The payment scales, they are similar. They must be treated alike. Okay, but unlikes, they must be treated differently. अब इसको एक एग्जाम्पल से समझते हैं. फॉर एग्जाम्पल, वाटर बिल है. If government makes a provision that everybody has to pay water bill and it is applicable to all the classes and the caste and to everyone on the citizen. Let's say Delhi government brings this law, and Delhi government through this legislation says that water bill has to be paid to everybody. This is an example of equality before law, that any liability which is imposed on people is imposed equally on all without any discrimination. So absence of discrimination, absence of favor, absence of partiality, वो कहीं पर भी वाटर बिल में ये प्रोविजन नहीं दिया गया है कि सिर्फ साउथ दिल्ली के जो लोग हैं वही वाटर बिल पे करेंगे, सेंट्रल दिल्ली वाले नहीं करेंगे, या वाइस वर्सा. इट्स नथिंग लाइक एवरीबडी इज गोइंग टू पे. इफ यू लिव इन द टेरिटरी ऑफ दिल्ली you have to pay the bill, water bill. Example of equality before law. But अगर एक provision इसमें डाला जाए that those who are poor, or let's say having a family income of 2000 rupees, 2000 rupees per month, they will be exempted from paying water bill. Now this is what is called equal treatment of similarly circumstanced people. अगर सिर्फ वाटर बिल की बात की जाए तो everybody who is earning, they are living, having a certain standard of life and is able to pay the water bill, the person who is able to pay the water bill will be considered as like and they will be treated alike. मतलब जो पर्सन एक बंगलो में रह रहा है and the cost of that bungalow is crores, also have to pay the water bill, and the person who is living in a 3 BHK flat also have to pay the water bill. The person who is living in one room also has to pay the water bill. Why? Because they are able to pay it. Whereas a person who is just earning 2000 rupees and less, the family income is 2000 rupees and less, will not be able to pay it. So for the matter of the water bill, that person is different. And since that person is different, they are not similarly circumstanced, they are differently circumstanced, and hence equal protection of law comes into picture. दूसरे एग्जाम्पल से, रिजर्वेशंस आर गिवन इन इंडिया. इंडिया में आपने देखा होगा रिजर्वेशंस आर गिवन पोस्ट एडमिशन, प्रमोशन. Okay, and reservations are given to classes such as scheduled caste, scheduled tribe, OBC. These reservations are given. Ab, if you give UPSC exam and the posts are open to all without any reservation, think about people who have faced historical and educational backwardness. How will they compete with you? उनकी generations जो हैं वो historically backward रही हैं, educationally backward रही हैं. They have not been given formal education from centuries. How can you expect such a girl or such a boy to sit in exam like UPSC and crack it? That's not possible. And if you apply equality before law concept that all are equal in the eyes of law, that simply means all the posts which the government is trying to fill will be filled without any reservations given, because everybody is equal in the eyes of law. Now that will perpetuate that will perpetuate inequality. सालों सालों तक SC, ST, OBC और जिन भी क्लासेस को रिजर्वेशंस दिए गए हैं वो एजुकेशनली, वो हिस्टोरिकली बैकवर्ड ही रह जाएंगे अगर रिजर्वेशंस नहीं दिए गए तो. सो दैट इज वेरी इंपॉर्टेंट दैट द रिजर्वेशंस आर गिवन फॉर द कम्युनिटीज, फॉर दोज क्लासेस टू बिकम सिमिलरली सर्कमस्टेंस्ड, टू बिकम लाइक, so that they can be treated alike like others. But if the classes are differently circumstanced, इस केस में circumstances अगर आप देखिए, so people who are coming from communities such as Kshatriya, such as Brahmins, they didn't have any educational or historical backwardness, but some communities in India had that, some classes in India had that. And that is the reason why equality before law cannot be applied as it is, but there has to be equal protection of law. There has to be provision where equal treatment is given to the similarly circumstanced people, not differently circumstanced people. So, if you're talking about, let's say, Brahmins, if you're talking about Kshatriyas, they are similarly circumstanced. They do not have any historical or educational backwardness. आप लॉ बनाइए, इनको आप रिजर्वेशन देने की कोई ज़रूरत नहीं है. एक कम्युनिटी जो है वो दूसरे कम्युनिटी के ऑलमोस्ट बराबर है, इक्वल है. कुछ लोग जो हैं वो एक कम्युनिटी के लोगों से ऊपर हैं, कुछ लोग जो हैं वो दूसरी कम्युनिटी के लोगों से ऊपर हैं, बट ऑलमोस्ट इफ यू सी इन अ रफ मैनर दे आर सिमिलरली सर्कमस्टेंस्ड. कुछ ब्राह्मण्स ऐसे हैं जो क्षत्रिय से ज़्यादा अच्छी पोजीशन में हैं, कुछ क्षत्रियाज ऐसे हैं जो ब्राह्मण से ज़्यादा अच्छी पोजीशन में हैं, बट इन अ वे they do not have any historical backwardness, they do not have any educational backwardness. So for the matter of reservations, इधर अपन ने पढ़ा था for the matter of water bill, इधर अपन पढ़ रहे हैं for the matter of reservations, they are similarly circumstanced, and since they are similarly circumstanced, they should be treated equally. But when you compare these classes with SC, ST or OBC, they are not similarly circumstanced, they are differently circumstanced, and when they are differently circumstanced, they cannot be treated equally. The treatment has to be different. The likes must be treated alike, but those who are not likes must be treated differently. This is what is the whole concept of equal protection of law, where a person who is given equally treatment is given equal treatment only when the person is equally circumstanced with the another person. इस पूरे केस में अगर कोई भी दो अलग अलग कम्युनिटीज हैं, क्लासेस हैं, कास्ट्स हैं जो इक्वल सर्कमस्टांस्ड में नहीं है, इक्वल सर्कमस्टांसेस जिनके नहीं है, at that time they should not be treated equally. Now comes reasonable classification doctrine. What is this reasonable classification? इसमें अपन देखेंगे there are two important things to study. First thing is classification, and another thing is the nexus between the classification and the object to be achieved. अब इस रीजनेबल क्लासिफिकेशन डॉक्ट्रिन को अपन लागू करते हैं वाटर बिल पे. गवर्नमेंट अगर वाटर बिल पे करने के लिए कोई नोटिफिकेशन लेकर आई या ऑर्डर लेकर आई और क्लासिफिकेशन ये करा गया कि जिसने अपने बाल लाल रंग से पुतवा रखे हैं, रेड हेडेड विल बी एग्जेम्प्टेड फ्रॉम पेइंग बिल्स. तो आपको लगता है क्या कि ये क्लासिफिकेशन रीजनेबल है? इट इज नॉट अ रीजनेबल क्लासिफिकेशन. यू कैन नॉट क्लासिफाई द सिटीजन्स ऑन द बेसिस ऑफ व्हाट कलर देयर हेड इज, of what color they are using for the hair color, okay, in the matters of the water bill. But अगर आपने provision लाया that the SCs and the STs doesn't have to pay the water bill, is it reasonable now? Yes, it looks reasonable. Why not? It looks reasonable. This classification looks reasonable. So classification has to be reasonable. There must be some reason, must be some objective behind classifying somebody. Now comes nexus between the classification done and the object. So in this case, in the water bill, what is the object to be achieved? Water is of course a very important element. It is responsible for a good way of life for the people. Natural basic right, human right में water आता है, clean water for drinking. So the object is quite clear. We want our people to drink good quality water, and for that they have to pay. For the treatment which needs to be done, the water treatment, for everything, the bill needs to be paid. Okay, so this is the object, but we have to give exemptions, and for that we have created some sort of classification. The classification cannot be based on what color you color your head with, neither it cannot be on the basis of caste, because there are many people in these communities who can afford to pay the water bill. So the nexus between the object which we are trying to achieve and the classification which is done is not proper. The nexus also has to be reasonable. So if you classify them on the basis of poor, a person is poor or not. If a person unfortunately earns 2000 rupees per month, the family income is 2000 rupees per month, they can be considered as poor, and it is understandable, very easily understandable, that they cannot afford to pay the water bill. इस condition में you cannot take water bill from the poor people. अब जो classification हुआ है पुअर्स का और जो एग्जेम्पशन मिला है पुअर का, नाउ इट लुक्स रीजनेबल. नाउ द नेक्सस बिटवीन द क्लासिफिकेशन एंड द ऑब्जेक्ट विच वी वर ट्राइंग टू अचीव, लिविंग स्टैंडर्ड लोगों का बढ़ाना, दैट वाज द ऑब्जेक्ट. हेल्दी पॉपुलेशन, दैट वाज द ऑब्जेक्ट. नाउ वी विल बी एबल टू अचीव द ऑब्जेक्ट विद द क्लासिफिकेशन डन. Everybody will be getting the fresh water, clean water, and at the same time poors will not be burdened. अब देखिए जो क्लासिफिकेशन किया गया एंड एट द सेम टाइम जो ऑब्जेक्ट था, इनके बीच में एक नेक्सस बना. दिस नेक्सस इज वेरी इंपॉर्टेंट. अगर क्लासिफिकेशन SC/ST के बेसिस पे होता तो बहुत से ऐसे पुअर्स हैं वो आर नॉट SC/ST. उस कंडीशन में क्या होता, आपके ऑब्जेक्ट अचीव नहीं हो पाते. पीपल वुड हैव बीन बर्डन्ड हियर जस्ट because they, and since they cannot pay, so they will be drinking unhygienic water, dirty water. Clean water अगर आपको देना है, so the classification has to be proper, it has to be reasonable, and the object, the clean water needs to be there, must form an nexus with the classification. So when reservations are given and the classifications are done, that which community must be called as scheduled caste, which communities must be called as tribes, which communities will be there in OBC, there has to be some reasonable basis. You have to prove that they were really historically and educationally backward, they were untouchables, they were considered downtrodden, and respect was not paid to generations. And that is the reason it is important for all of them to bring into the mainstream society. We have to provide reservation. That was the thinking of the framers of the constitution. In order to stop inequality in the society, in order to eradicate inequality, the two concepts of equality before law and equal protection of law has to go hand in hand. Equal protection of law, which provides affirmative action, is as important as the equality before law concept. And that is the reason why reasonable classification doctrine becomes very important. That whatever object you are trying to achieve, कुछ भी object है आपका और उसके लिए classification आपको करना पड़ रहा है, classification has to be reasonable, and the nexus between classification and object which you are trying to achieve also has to be reasonable. पानी का बिल exempt हो जाए just because आपके बाल लाल हैं, this is not a reasonable classification. At the same time अगर आप SC या ST community से हैं, that is why आपका पानी का बिल, that is also not a reasonable classification. But if you are poor and then you have been exempted, that is a proper reasonable classification. For the matter of water bills, this classification is most reasonable. उसी तरीके से for the matter of giving reservation in posts, admission and promotion, क्लासिफिकेशन कुछ अलग तरह से होता है. EWS का क्लासिफिकेशन इक्वली इकोनॉमिकली बैकवर्ड सेक्शंस, ये क्यों लाया गया, ये किस बेसिस पे किया गया? So there is some basis on which this classification is done, that your family income should not be above certain amount, or you must not hold a land beyond this limit. Then you will be called as a person belonging to the economically backward section. And they can be anybody, can be the SCs, can be STs, they can be Brahmins, they can be Kshatris, they can be anybody, but they are suffering because they comes from the economically backward section, and it is important for us to give reservations to them so that they also have representation. अब आप सोच के देखिए, कोई ऐसा ब्राह्मण जो बहुत सालों से और जनरेशन से गरीब है, how will he be able to afford good studies? How will he be able to afford to sit in exams like prestigious exams like UPSC without any help? That's not possible. That simply means if you apply the concept of equality before law as it is, you will perpetuate inequality in the society. Equality को follow करवाने के लिए equal protection of law and equality before law both have to be implemented properly. Now comes class legislation. This is simply what we have already discussed. It means picking up few people. Let's say there are 100 people in total, picking up few and giving them some sort of favor or putting liability. That is what class legislation is. अगर government कोई bill लेकर आती है and that is passed as an act which classifies people, few people which have been given several favors by the government, and that reasonable classification is not at all there in the picture, then it will be called as a class legislation. ये एक tool है inequality बताने के लिए. There must not be any kind of legislation which is a class legislation, which simply means that when you are doing the classification, you are not doing it on the reasonable basis. So I hope you have understood the concepts of equality before law, equal protection of law and reasonable classification doctrine, which is covered under Article 14 of the Constitution. And at the same time, I hope you have understood the concepts of what all are the content of the fundamental right of the citizens in India. Thank you very much for joining me. We will be coming up with the next lecture with another exciting topic. Thank you very much and hope to see you next time.
SRIRAM's IAS, serving the nation since 1985. Ab offline ho ya online, we are the lifeline.